So a very good afternoon to everybody. So let us start today's session. I just hope everyone have read whatever we have studied in the last class. Yes or no? There was a break, so let me just check whether you remember or not. Whatever we have discussed. Yes or no? Okay. So in the last class we started with the topic acceptance. Acceptance is defined in which section? Clause B of section 2. Okay. Who gave the relationship between offer and acceptance? Sir William Anson. And what was the relationship made by him? Yes. In that, what is gunpowder and what is lighted matchstick? What happens when they both meet? Yes. Okay. So, can you take back once acceptance reaches offer, can you take it back again? No, you cannot take it back. So, if it is train of gunpowder also, once there is an explode, train of gunpowder, you have lit a matchstick to it, explode, can you again get that gunpowder? You cannot get that gunpowder, okay? So, that was the relationship made. Now, let us see various legal rules regarding acceptance. So, what are the legal rules that we have seen? What was the first one? It is made. What is the case law? Bolton versus Jones. Next one must be absolute and unqualified. What is that you mean by unqualified? Unconditional. If you make conditional acceptance, then it becomes counter offer. Very good. Next. Okay, in case of acceptance must be absolute and unqualified. What are the case laws that we have discussed? Neil versus Merritt. What was the fact? What were the facts of the case? Neil versus Merritt. Come on, come on, come on. At 280 pounds. And what was 5 installments? Yes. And what was Union of India versus Bahulal? Purchase of land. 1 lakh. He told I'll purchase at 80,000. Remember? Acceptance must be communicated. What is the case law? Brogden versus Metroport. What was this case law about? Supply of coal. What did the manager do? And kept it in the drawer, forgot to inform, communicated with the Brogden. Therefore, no communication, no acceptance, no contract. Bhagwan Das Giridharilal, I told you it was regarding place of contract. Why place of contract is required? At which jurisdiction, yes, Ahmedabad it was. Yes, it was at which jurisdictional court the case is to be accepted. Where it should be accepted? Wherever acceptance is received. Here in this case it is Ahmedabad. Okay. Hayworth and Knight is also regarding that only. Okay. Acceptance must be in prescribed mode. Remember everybody? Prescribed mode. Time. If time limit is given, within time limit. If no time limit is given, then very good. If time limit is given, think before you say. Think before you say. If time limit within specified time, no time limit, then reasonable time. Reasonable time nowhere defined in the act. It always depends on. You cannot say like that. What is the term I used? Reasonable time. Reasonable term always depends on. Always depends on. Very good. Very. That is the reason I tell you. Please note down whatever I am telling. You will forget. This line you have to write. अगर टाइम पे अगर कोई भी केस लॉ आता है, if you get any case law, then you should say that it should be within specified time, no time specified, then reasonable time. Reasonable time is not defined in the act. It depends on the facts and circumstances of the case. Very important. That is the reason I always tell you to make a note of all the things I am telling you. You tend to forget them. Okay. Mere silence, not acceptance, case law. Feldhaus versus Binley. Remember, auctioning of horse, forgot to communicate. Okay? Yes. Acceptance by conduct, implied acceptance is also valid. That means I am just telling you, I want to purchase 100 bales of cotton from you. I'm just telling you. Instead of saying a yes, what did you do? You delivered me 100 bales of cotton. Is it valid acceptance? Yes. You didn't speak anything, but by your actions, you accepted my offer. But if in terms and conditions of offer, if the offerer says, before doing actions, you first have to give me the acceptance. Either that is express acceptance, then you have to expressly accept. Okay, clear with this? Oh. So we have discussed till here. Then we started with a new topic, that was communication of offer and acceptance. So we have just seen the introduction of this part. So effective and proper communication. Yes, let us now go through whatever we have discussed once again. Okay, so that there is introduction that you know, and then we can start off with the main topic. Effective and proper communication prevents avoidable revocation and misunderstanding between the parties. If there is effective communication, then there is no misunderstandings. Communication means what? Here, what is that you're communicating here? What is that? Offer, in offer, all the terms and conditions. I will offer you this time, I will offer you this place, I will offer you this much, I will offer you this quality of goods, I will offer you. All these are terms and conditions that you will discuss. So all these terms and conditions should be communicated in offer as well as acceptance. When you're accepting, you'll say, okay, I will accept. So this time I will accept, or these are the goods I want to accept, this is the quality I want to accept. Okay, so all these terms and conditions should be clear between the parties. If it is clear, obviously there will not be any misunderstandings. But say if these are not clear, say you wanted to offer some A grade goods, and that person wanted to accept A plus grade goods, then will there be not misunderstanding between you if communication is not clear? Yes. That is the reason communication of terms and conditions should be effective to avoid misunderstanding between the parties. Okay, who are the parties here? Offerer and the acceptor. Yes or no? Okay. When parties are face to face, there is instantaneous communication. Instantaneous means immediate. Immediately there is communication. I say I want to do this, you say yes, yes, I will accept this, then finish. Contract came into existence. Yes or no? So instantaneous communication of offer and acceptance. In such a case, the question of revocation does not arise, since offer and its acceptance are made instantly. When can you revocate something? When can you take back something? When the contract is not formed. Till the contract is not formed, you offered. You gave that person 5 days time. I am telling you that I want to sell you my car at 5 lakh rupees. I am giving you 5 days time to accept. But second day, still you did not accept. Second day only I changed my mind. I am saying that no, the car is nice. I want to keep the car with myself. Or I can think that no, I will sell the car to someone else. Second day only I am coming and telling you I don't want to sell you my car. Can I do that? Yes. It is still an offer. It did not become a contract. Yes or no? Did you say a yes? I gave you 5 days time. Okay, you still did not say yes. Second day only coming. I'm coming and telling you what? I am taking back my offer. I gave you offer. I am taking back that offer. That is known as what? Revocation. Understood? Anyways, revocation also we'll see here. After communication of offer acceptance, we have revocation of offer acceptance. There we'll see again revocation. So, if it is instantaneous, immediately contract is coming into existence, can you revocate? I am telling you, I will sell you my car. I did not give you any time. I told you that if you want the car, tell me immediately yes or no. You said yes, I want the car. Then finish. Contract came into existence. Can I take back my offer now? No. Can you take back your acceptance? No. Then finish. Once contract comes into existence, it cannot be revocated. But if contract did not come into existence, then you have still time to revocate. Okay. The difficulty arises when the contracting parties are at distance from one another and they utilize the services of post office, telephone or email. Post office, telephone or email. In such cases, it is very relevant for us to know the exact time when the offer or acceptance is made or complete. Why it is very important for us to know when offer is complete and when acceptance is complete? Think and tell me. Why? Think and tell me. Goods वगैरह कुछ नहीं. I didn't tell you anything about goods, car. Hmm? Why it is very important for us to know the completion time when offer is completed, the time when acceptance is complete. Why? Contract should be in enforceable by law ही रहता बनता है तो why? Just now I told you when can you revocate? When there is no contract. When you come to know time of offer is complete, time of acceptance is complete, you will come to know the time for contract is also complete. Contract came into existence. Now you will not have any rights. So for you to know whether you can take back, whether you cannot take back, for that it is very important for you to know when that happened. When did offer complete? When did acceptance complete? Okay, today acceptance complete or tomorrow it will complete. Then tomorrow, today you can revocate, but tomorrow can you revocate? No, because of contract came into existence. So time for completion of offer and acceptance is very, very important for us to see what rights we have in it. Once contract came into existence and the other party is saying, I will not perform, can you go to court of law and file a case? Yes. Contract, the parties will have to perform. Any party saying a no, then can you go to court of law? Yes. But still contract did not come into existence. The communication of offer is complete, but still communication of acceptance is not complete. And here offerer is telling, I will not perform. Can acceptor when go to court of law and file a case? No, he did not give the acceptance. No contract came into existence. No one can go to court of law. For this point clear? So for you to know what rights you have in the contract, whether you have or not, whether you can revocate or not, it is very important for you to know what is the time for offer, what is the time for completion of your acceptance. So you will know the contract came into existence or the contract did not come into existence. Clear with this? That is the reason we are studying this now. That is the reason now what is that we are going to study? The time for communication of offer when it is complete, time for communication of acceptance when it is complete. Okay. Okay. Now this we are going to start this section. This section is actually considered to be outdated section nowadays. Why? Because there are so many means of communication where there is instantaneous offer, instantaneous acceptance. Yes, on telephone you have. The contract was made when 1872. That time you did not have any means of communication. You had only one means of communication, that was postal services. And that time postal services used to take weeks and weeks for a person to send a letter and to receive a letter. Not nowadays which you take 3 days, 2 days, speed post, courier and telegrams where immediately the messages are sent. No. That time it used to take weeks and weeks. So when they are near to each other, they used to speak and enter into contract. But when they are far at far places, nowadays what we do? We send emails, immediate contract. We speak on telephones, immediate contract. WhatsApp messages, immediate contract. Or faxes we use, all these are what? Immediately contract is coming into existence. But that time when they were at distant places, what they used to do? Only postal service. It was very, very difficult for them to know what is the time when offer is reached, what is the time when the acceptance is reached, because it used to take so many days and there was lot of conflicts. No offer is complete for me, other party is saying acceptance is not complete, one is telling it is complete, one is telling contract came into existence, other is telling no, it is not, the contract is not coming into existence. So there was lot of chaos. That is the reason this section was made. But nowadays, do you think it is of any use, this section? It has become totally outdated. Totally outdated, but from exam point of view, very very important. Why? Because this is not very easy for you to understand. Okay, now I'll explain you, try to understand properly. Not very easy, it is complicated. And because it is complicated, obviously examiner will test you. He knows that this is complicated part, and he will know it is a part of the act. He will test you on that. Understood? Okay, let us see now. I'll give you one example. With that example, we'll understand. Then again, we'll come to this and we'll read this once again. Okay, so that you can understand it. Okay. Please write down the example also as I'm writing. You also write down. Okay. Now, in this case, whenever the parties use telephonic communication to enter into contracts, that time always the communication, the contract comes into existence when the acceptance is received by the offerer. Who should receive the acceptance? Offerer, obviously. Who will give the acceptance? Offeree. That is, acceptor will give the acceptance. So that in face to face also, that is only the case. I am the offerer, I am telling you, I want to sell you my house. When you say yes, yes, I want to purchase the house, then the communication of acceptance is complete. Once the communication of acceptance is complete, then what will happen? Contract comes into existence. Yes or no? Generally speaking, in face to face or immediate communications, there is no problem. No problem at all. Main problem arises when the communication is through post. Communication through post. Okay, so that is what we are going to see. Otherwise, there will not be any problem. The problem will arise only here. A and B are two parties. A is offering B, I want to sell you my house for 1 lakh rupees. I want to sell you my house for 1 lakh rupees. This is the offer given by A. So now you tell me which party is offerer here? Which party is offeree? The person to whom offer is given, B is the offer. How it was given now? It was given by post. A has sent a letter to B on, say, 1st of July. What happened on 1st of July? The letter was sent, letter of offer. Letter of offer was sent to B, and when it reached, generally normally we are taking not speed post, 5th of July it reached. This is regarding letter of offer. Now on 5th of July, B saw the letter of offer, read the letter of offer. He also wanted to buy the house. So he thought for one day, 5th entire day he thought, okay, I want or I don't want. He whatever is beneficial for him, he took the rational decision. And on 6th of July, what did he do? He sent the letter of acceptance to A. Letter of acceptance was sent on which date? 6th of July it was sent. And when did it reach? It reached on 10th of July. It reached A on 10th of July. So this is what happened. So communication was made by post. On 1st of July, letter of offer was given and it reached the offeree on 5th of July. 6th of July, offeree sent the letter of acceptance to offerer and it reached on 10th of July. Now law is telling when is communication of offer complete. In law, 10th of July. Anything else? That is the reason, listen to me. You will not get this. Okay? When is communication of, I didn't tell you acceptance, when is communication of offer complete? So listen to me carefully. Communication of offer is complete when the offer comes to the knowledge of offeree or acceptor. Offeree. When did it come to the knowledge of offeree? 5th of July. So on this day, what is complete? Only communication of offer is complete. Did contract come into existence on 5th of July? No. How will it? Why? Because only what is complete still? Communication of offer. Acceptance is not complete. Okay. So, offer. Communication of offer is complete when it comes to the knowledge of offeree. Offeree I am telling, or here you can write the other person. Who is the other person here? The offeree. Now, listen to this carefully. Here they are clearly saying when it comes to the knowledge of offeree. Here they did not specify the term when it reaches the offeree. When it comes to knowledge of offeree here means it should come to the knowledge of offeree. Say for example, listen to this very carefully. Letter reached on 5th of July. It reached the house of B, but still B did not know about it. It is reached B is somewhere doing some work he did not know. He came to know about it only on 7th of July. Then the communication of offer will be complete on 7th of July. So here they are not mentioning when it reaches the other person. It is they are mentioning when it comes to the knowledge of other person. That means it is reached as well as he has read it. Both the things should happen. Then only communication of, if you take sense in that, logic in that, obviously if it only reached, how will he come to know about the terms of the offer? No, right? Yes or no? That is the reason it should reach. That is not enough. It should come to the knowledge of the other party. Clear with this? Yes or no? No. So that is regarding communication of offer. Now, communication of accent. This is something which is very confusing, but law has given it like this. As I told you, if law is telling you something, you have to read it as it is. Law is saying a plus b is equal to c. Can you say a is equal to b minus c? No. You should say a plus b is equal to c only. Yes or no? So because it is given, you have to read it like this. Anyways, what is the logic behind it also? I'll explain you. Okay. Now, in this case, acceptance, when the communication of acceptance is complete. Communication of acceptance. For this, law is dividing this into two. Law is telling that communication of acceptance will be complete for the offerer at one time, for the offeree at some other time. Okay, that is what law is saying. Communication of acceptance should be complete for the offerer at one time, for the offeree at some other time. So, communication of acceptance complete as against as against offerer, as against offerer. It is complete when, the letter of acceptance, when the letter of acceptance is put in the course of transmission, put in the course of transmission, put in the course of transmission. What is put in the course of transmission? Here, put in the course of transmission means what? Posted. When it is posted, for that letter, for that information to reach the other party, you have put in the course of transmission. Now it is getting transmitted. It did not get transmitted, but it is in the process of getting transmitted. Why? Because immediately, I told you, immediately will not have any problem. Immediately telephone, face to face, immediately contract will come into existence. But when there is some time limit between the messages to be reached, obviously it will happen only in case of posts. Yes or no? So in case of post, this is what you have to follow. So what is law telling? That acceptance, communication of acceptance complete as against the offerer when it is put in the course of transmission. In our example, tell me when communication of acceptance is complete for offerer. 5th of July. And anyone else? 6th of July. 6th of July is correct. 5th of July, it only reached the offeree. But when did he post? When did he post? 6th of July. So it is put in the course of transmission when? On 6th of July. So communication of acceptance is complete for offerer when? 6th of July. Don't worry, you'll get a lot of confusions in this. I'll clarify everything. Let us just complete the topic, then we'll see the clarity on it. Okay. Now, as against the offeree or the acceptor, or the acceptor, when it comes to the knowledge of, whose knowledge this should? Very good, offerer. When it comes, why? Because we are talking about what here? Communication of acceptance. Acceptance is given to whom? Offerer. Therefore, many students get confused between only these terms, offerer and offeree. Instead of writing offerer, they write offeree. Instead of writing offeree, they write offerer. Just confusion. They know everything. They know everything, they understand, but just because of confusion that happens. That is the reason you should understand when what is to be used. So as against the offerer, offeree or acceptor, when communication of acceptance is complete, when it comes to the knowledge of the offerer. When it is complete for, very good. 11th, कौन पढ़ लिया? आपका अलग कंफ्यूजन है मैं सॉल्व करती, डोंट वरी. ओके, एनीवेज, बाकी सबको समझ आया? सबको? आपको? I'll explain. Okay, I understood your doubt also. I understood what confusion you have also. Don't worry. Okay. वैसे as we proceed, you will understand. Anyways, after class, I'll explain once again to you. Okay. So remaining everybody, when communication of acceptance is complete for offeree, 10th July. 10th July, when it came to the knowledge of offerer. When it came to the knowledge of offerer. Now, if you see here, as against the offerer, what are they saying? When it is put in the course of transmission, done. For you, acceptance is over. Now you will think, one thing will come into your mind. Offerer did not read anything. How will he know that he is saying yes or no? How will he know that? That thing will come into your mind. Here, see, what law is saying that obviously once letter is posted, letter is posted for what? For it to reach the offerer only. Yes or no? So the main purpose of contract was what? I wanted to sell you house. You are saying a yes, then contract should come into existence actually immediately. But here law is saying that it should come into existence immediately when actually offer and acceptance is put into course of transmission. Why? Because we have seen in essentials of offer that always the intention of offerer is to get the assent of the other party, and he got the assent. Law is saying when he got the assent, immediately contract came into existence for him. Anyways, he wanted yes. He got that yes. When did he get that yes? 6th of July, he got that yes. Because he is using that means of communication that is taking some time. That is the reason it is taking time. Otherwise, if you are face to face, contract should have come into existence immediately. Yes or no? You gave the offer because you wanted yes, and you got that yes on 6th only. So for you, contract came into existence on 6th. Now, as I told you, why there is this time limit, why you have to see when it is complete, so that the other party does not revocate it, cannot take it back. Now contract came into existence for this offerer on which date? 6th of July. 6th of July. There should not be any confusion. When the communication of acceptance is put in the course of transmission, so that it is now in no person's hand to change it. Why? Because now this communication is with whom? Postal authorities. Acceptor offer is not having anything, and the offerer is also not having anything. It is in whose hands? Postal authorities. Can you change now? No. That is the reason law is saying you wanted yes, you got yes on 6th, now you cannot take it back. 6th contract came into existence for you. For whom? For the offerer. Got this point clear? Yes or no? Now for the offeree, when the contract came into existence, that is when the communication of acceptance is complete, when it comes to the knowledge of offerer, that is which date? 10th of July. That means 6th of July से 10th of July तक still B is having time to take the acceptance back. Yes or no? Can he say on say he'll call A and tell on 8th of July, I already sent the letter saying a yes, but now I don't want to purchase the house. Can he say that? Yes, it is very much valid. Why? Why? Because for B still contract didn't come into existence. No, I am telling nowadays. That is the reason I took only 2-3 days. No, nowadays also people use post. Why do you think they use post? Why? Because they want written evidence. Hmm. Hmm. Telegram. You have many other means which will reach faster than post also. Telegram डाल सकते हैं आप. पोस्ट है तो आप कुछ भी नहीं कर सकते. वो टाइम पे आप कुछ भी नहीं कर सकते. नहीं. आप उसके घर जाकर बात करो. वो एक. You can go to his place and talk. वो एक है. That time, अभी we are not living in. That is the reason I am telling you outdated हो गया ये. Okay. Many other means. If you don't want to purchase the house, there are many means where you can use and say no, I don't want to purchase. Will you wait? नहीं नहीं, I want to use post only. जान दो, post तो नहीं कर सकते. जान दो, I'll purchase. Will you think like that? Obviously not. Why will you think that? You have other means of communications. Yes or no? You will not do that. अगर अभी है समझो फोन उन्होंने नहीं उठा रहा, कुछ आपका रिप्लाई नहीं करा, कुछ नहीं, इमीडिएटली फ्लाइट लो, जाओ, पहुंच जाओ 2 घंटे में, done, finish, face to face. I don't want your house. Yes or no? Is that not available? Nowadays it is there. That time you didn't have. Postal services were there, use that, otherwise face to face. Two only. Okay. Anyways, that is the reason outdated. ये section ही outdated हो गया अभी. क्योंकि most of the people very rarely they use this. आजकल सब emails, through emails, letters also you're using emails है, fax है, okay, WhatsApp messages है, आज तो phone है हाथ में, तभी का तभी करो, तभी देख लो, done, finish. Clear? There's so many other means. This has become outdated, but because ये confusion यहाँ created है, that is the reason examiner will ask you questions on this. Clear with this? Okay. Now, did you understand why 2 times are given for communication of acceptance? Did you understand the logic behind it? Anyways, it is not given anywhere. Just for your understanding, I am telling you. Ki law, what he's saying, what was the purpose offerer you gave an offer? Because you wanted other person to accept it. And he already accepted on 6th. I will not give you any more time. For you, contract came into existence. Why? Because here, offerer also had time to revocate. From which time? From 1st July till 6th of July. 6th of July only. Before what was, when the communication of acceptance is complete for offerer, when it is put in the course of transmission. When it is put in the course of transmission, 6th. Before that, from 1st till say 5th, okay, 6th he cannot do anything, till 5th, is he having time to revocate? Yes. Who is that? No, no. Okay. It'll take time. Don't worry. That is the reason before only I gave this disclaimer that it is difficult to understand. It is confusing to understand. This happens. This topic is like that. Anyways, as I tell you, as I'm going on telling you, then you'll understand. Okay? Clear with this? Okay. Now you tell me. Now you tell me. Only seeing this, you tell me. A is the offerer, B is the offering. A is giving the offer to B for purchase of house. Now you tell me when the communication of offer is complete. When the communication of offer is complete. Why fifth? Tell me why. Tell me the proper sentence. Why fifth? What is coming to the knowledge of offeree? The the offer. Yes. So the communication of offer is always complete when the offer comes to the knowledge of the offeree. That is nothing but that is 5th of July. Now you tell me when the communication of acceptance is complete, when the communication of acceptance is complete as against the offerer. When the letter is put in the course of transmission, so it is not in the power of any parties to change it. Put in the transmission, done, finished, not in anyone's hand. Now, for whom communication of acceptance is complete now here? Offeree, offeree. यही confusion होता, यही confusion है, okay? Sorry, communication of acceptance, he's right actually. Communication of acceptance is complete as against the offerer. Offerer. He's right. When it is put in the course of transmission, it is complete. Rest, everyone is wrong. He was right. Okay. So I should tell you this is how the confusion happens. Tell me also this is how the confusion happens. Okay. So tell me, when is the communication of acceptance complete as against the offerer? When it is put in the course of transmission, that is 6th of July. Clear? When the communication of acceptance is complete as against the offeree, when it comes to knowledge of offer ऑफरर एक्सेप्टेंस कभी ऑफरी को नहीं देते ऑफर ही देता है ऑफरर को यू गिव इट टू ऑफरर सो इट कम्स टू नॉलेज ऑफ ऑफरर एंड व्हेन डज दैट हैपन 10th ऑफ क्लियर आया समझ में भी लेट अस रीड फ्रॉम द मटेरियल नाउ वंस अगेन एग्जाम्पल तो समझ आया सब नोट डाउन कर एग्जाम्पल आपको नहीं समझ में आया आफ्टर क्लास विल सी ओके लेट अस रीड okay. This communication of offer and acceptance is given in which section? Section 4. Section 4 of the Indian Contract Act 1872. So, in terms of Section 4 of the Act, the communication of offer is complete when it comes to the knowledge of the person to whom it is made. To whom it is made? Offeree. Thus, when proposal is made by post, its communication will be complete when the letter containing the proposal reaches the person to whom it is made. I'll give you this. Okay. When the communication of acceptance is complete. In terms of section 4, communication of acceptance is complete as against the proposer, that is nothing but your offerer. Offerer. As against the offerer, it is going to be complete when it is put in the course of transmission to him as so as to be out of the power of acceptor to withdraw the same. It is not in his power to withdraw the same. And offerer, you wanted that only. You wanted a yes. You got that. So it will be a contract from you for you from that time when it is put in the course of transmission. It will be a contract for you. As against the acceptor, that is your offeree, when it will be complete, the communication of acceptance it will be complete when it comes to knowledge of the proposer, that is the offerer. Clear? Okay, now when you see communication of acceptance, there are two issues. One issue is when it is complete, when communication is complete, which we have just now seen. When it is complete, we have seen under two heads, as against the proposer, as against the acceptor. We have seen when it is complete. For proposer, it is complete when it is put in the course of transmission. And for acceptor, when it is complete, when it comes to knowledge of proposer. Yes or no? Second is mode of communication. Mode means what? What is that you mean by this term mode? Ways. That is means various ways. How you are communicating. You are communicating. When you are communicating, when it is complete, that we have to see. We have to see how the communication is made. For acceptance, how it is made. So there are various modes of communication. Here they are telling only about acceptance. That is saying a yes. How can you say a yes? You can say a yes by two ways. One, by doing some acts expressly. So here they are saying the modes of communication are having two parts. One is positive and one is negative. Positive is to do something, negative is not to do something. Remember, abstain from doing also we had. So here also, if you say, for you, I will not do this, then you are accepting it. That is one way of acceptance. For you, I will do this. That is also one way of acceptance. Yes or no? So here these are two modes of acceptance. One mode is known as by doing something. Second one is known as by omission. Omission means what? Omission means what? Not doing something. Abstain from doing something, that is omission. Doing is positive, omission is negative. So what are the two modes? By act. And another is by omission. Act is positive thing, omission is negative thing. Okay, so let us read this. Communication by act. In both these cases, both the cases, that is act and omission, both can be either express or implied. Here also it can be either express or implied. That means what? By using words or by actions. You can say yes by using words or actions. You can say no by using words and action. Here you don't get confused that you are saying no to the contract. No, no. You are accepting the contract, but the offerer told you not to do something for him, and you are not doing that thing. You are accepting not to do that thing. That is acceptance. Here we are talking only about acceptance. Here we are talking only where the contract is coming into existence. If say I am telling you I want to sell you my car, and if you are saying no, no, I will not purchase car from you, then is there any contract? No. Here that is not, that no is not that no where contract is not coming into existence. What is that no where? Say remember I told you regarding classes, coaching classes, where one person is saying don't take coaching classes, I will give you this much money. You are saying okay, I will not take coaching classes. So here you are not doing something for me, for my contract. Therefore that is acceptance. By omitting to do something, acceptance. By doing something, acceptance. Clear with this? Please don't get confused. If there is any confusion, please take that point, I'll explain you after class. Again, abhi so there's no confusion. Everybody understood what is doing and what is omission. So these are various modes of giving the acceptance. Modes of communication of acceptance by act, by omission. Act can be express or implied. That means if I am telling you that I will sell you 100 bags, I want to sell 100 bags of wheat to you. Sorry, I am telling you I want to purchase 100 bags of wheat from you. What are you doing? You're not saying anything, yes or no, but you came and delivered 100 bags of wheat to me. Is it not positive way of accepting? But that is which way? Implied. By conduct you're doing it. Valid communication of acceptance. Implied also it will be valid, and express also. And say if omission, I'm telling you not to, what do you say? Not to take the coaching classes. Okay, you didn't say anything, but what did you do? You, you went to your class and you have pasted a board saying that no more classes will be going on. The classes have been stopped. So by actions now, did you agree to my terms? Yes. By actions, you are saying what? I will not take the coaching classes. That is also very much valid. It can be express or it can be implied. Your act can be express implied, or your omission can be express implied. Both are considered to be valid way of communication of acceptance. Clear with this, everybody? Yes or no? Oh. In case of communication of acceptance, the effect of act, omission, conduct must result in communicating its acceptance or non-acceptance. If there is no communication, see, whatever act you're doing, whatever omission you're doing, whatever conduct you're doing for that act or omission, it should give that impression to the other party, that communication should reach the other party, that you are giving the acceptance. But whatever you did, still it did not reach the other party, then is it valid acceptance? No. Your communication should reach the other party, then only it is considered to be valid acceptance, otherwise it is not valid acceptance. See, in this case, there is Central Bank Yotmal versus Venkatesh. In this case, what happened? I'll just explain you the case, okay, to understand. This person is the customer for the bank. He took some loan. What did he do? He took some loan, and when you take some loan, will that bank give you, okay, you want 20 lakhs loan? Okay, take it. Or they'll ask for some security. Obviously, they'll ask for some security. Yes or no? Bank, obviously, they are authorities, they are not your friends or relatives that they'll give you without any reason. Okay, take, no problem. Anytime you give, not a problem. Will that happen? No. They will obviously take some security. Security can be in the form of movable property or some immobile property. It can be, say, some vehicle or some jewelry, that is mobile. Or it can be in some immobile property also, land, building. It can be immobile also. So this person, what did he do? He gave his land as security. Okay. He gave his land to this bank for security. Now you know what is the rule of the bank. Generally what happens in the bank? There is a time limit within which you have to repay. But if you're not repaying, then what will they do? They will sell off the land. Sell off the land. Say he has taken loan of 10 lakh rupees. And generally banks, what they do, whenever they take security, they take off higher value. You have taken loan of 10 lakhs, but the security value will be higher than the amount of loan. Why? Because they want some margin amount. Obviously, they'll take. Not exact or not less. Some margin should be there for banks. That is their policy. Okay. So 10 lakh rupees, but the land was worth, say, 15 lakh rupees. Okay. So now when this central bank is selling the land, say to some Mr. A, he has entered into contract that I will sell you land, but how much this bank will get? This bank will get obviously 15 lakh, but the loan amount was how much? 10 lakh. Excess is how much? 5 lakh. That 5 lakh is again to be returned to the customer. That they will return back. They will take their loan amount plus their interest. If there is any pending interest, that they'll recover. Anything over and above what is due from the customer, that they will return back to the customer. So in this case, all these terms and conditions were discussed between central bank and the customer, but nothing was discussed with Mr. A. Only one contract, okay, I will sell you, you purchase, but nothing that if there is over and above value, you have to pay it to the customer, that value paid to us, nothing was discussed. There was only discussion of the contract. But don't you think all those terms and conditions were to be discussed with Mr. A also? Yes, it is to be discussed. It is to be discussed. Why? Because that money is to be given to Mr. He should know that whatever land I'm purchasing, whatever value sale consideration I'm giving, that sale consideration is given to whom? To bank as well as to the other person. Afterwards, say if this Venkatesh will come to Mr. A and say, no, 5 lakh extra you have now, give me that money also. Will he give that? No. So there has to be tri-party agreement here. 3 parties in the agreement: bank, customer, as well as this new seller. Got this point clear? So that there is no misunderstanding afterwards. Don't you think afterwards he can come to Mr. A and ask? Obviously he will ask. Obviously Mr. A will not be responsible. He will file a case against bank only. At the end bank will be responsible. But will there be any disturbance to him? Yes, there will be some person is coming regularly calling you, give me my money. Will there not be any disturbance for you? Yes. So everything, all the terms, all the details is to be given to this party also. But the communication was not proper in this case. Though because it was not proper, therefore this sale agreement was not considered to be a valid contract, as the communication was not valid. Clear everybody? Yes or no? So here law is saying that whenever you communicate something, the communication should result in proper communication. Then only it is valid, otherwise that communication is of no result. Got this point clear? Yes or no? Understood now? Did you understand till here? Everybody? Okay. Now, again let us come to the example. There are few points which I want to tell you. Okay. Now if you see here, contract is coming to existence for A and B at two different dates or same date. Contract, listen to what, see this is going to be very confusing. Don't get distracted. Please listen to me properly, everybody. In the given example, contract is coming into existence for A and B at the same date or different dates. Different dates. Why different dates? Because it, anyone, one person at a time. Come on. It took time to reach. Okay. Anyone raise your hand. Come on. Who is going to answer? Together we'll say. Okay. We'll say wrong also. No problem. Together we'll say everything. But singly we'll not say. Is it like that? Hmm? It'll take time to. It'll take time to reach. That is what you're saying. It'll, it'll get time to take to get into knowledge of A. Okay. A. Something you're telling everybody. I want single same one important point I want only that much. I'll ask you question once again. I am telling you contract came into existence for A and B at two different dates. Why? They are at other place. Because the communication of acceptance is different for both of them. Communication of acceptance is complete at different dates for the both of them. You tell me when contract will complete, only when acceptance is complete. But here the acceptance is complete at two different dates. That is the reason contract is coming to existence at two different dates. What is that comes to knowledge, or they are distant, they are at distant places, or it will take time for each. What is law telling you? What is law giving you? Two different time. Law has given you that for A it is this time when the communication of acceptance is complete. For B it is this time when communication of acceptance is complete. Therefore it is two different times. What is important here? Very important. Sir William Anson. Once the acceptance reaches, contract comes into existence. Here we are talking about that only when this acceptance is complete. When this acceptance is complete. Is it complete on one single day or two different dates? Two different dates for offerer and offeree, no. Contract is coming to existence for offerer on which date? 6th of July. Yes or no? Contract is coming to existence for offeree at which date? 10th of July. Two different dates contract is coming. Yes or no? Now you tell me, sometimes what happens? Listen to this carefully. Listen. I know it is very much confusing. Two different dates, one date. What is happening here? Yes or no? You listen to me carefully. Okay? Now, it is put in the course of transmission. The communication of acceptance is put in the course of transmission by this person. B. What did he do? 6th of July. Went to postal offices, wrote everything, sealed, named, proper address given. Everything is done. Everything was proper. And it is put in the course of transmission to A. Now on 6th what happened? Contract came into existence for A. Now, compulsorily, he will have to give the house to B. B will have to pay the money. Contract came into existence for A actually. Whatever his promise, he will have to perform now. Now, when it was with postal offices, the letter got misplaced. What happened? The letter got misplaced, lost somewhere. Now, do you think it will reach A? And when is communication of acceptance complete for B? When contract will come into existence for B? When it comes to knowledge of A. Will it come to knowledge of A? Lost. There is no letter. It is lost by postal authority, is not available. Contract came into existence for A, but contract did not come into existence for B. Is it not an awkward situation? Yes or no? Whatever A you have to do. B, you want to do, you don't want to do, your wish. Is it not that situation? Why? Why? Because of fault of any of the parties here? No. Because of the fault of some other parties this happened. But this is only going to apply. Law is telling and it will going to apply. It is going to be like this, that for A contract came into existence, for B contract did not come into existence. That means anytime, say 10th, 11th, 12th, 13th, anytime, can anytime B say or no to the contract? No, I will not purchase the house. Why? Because never it came into never the contract came into existence for B. But can A anytime say no to it? He will have to perform the contract. Got this point clear? See, I said a yes, I want to sell, I will sell. You said a yes, you want to purchase, you will purchase. This losing of the, it'll take say 10th, 11th, 12th, still B did not get the house, B will call. Or say come, or again write a letter saying that I accept. That is very much possible. Why? Because he wanted to purchase. Again the contract will come into existence. But I am telling you, what if he says a no? He's saying a no after many days also. Will it be valid? Yes, it will be valid. Now say 10th happened, 11th happened, 12th, still the letter did not reach A. A is saying that maybe it is replaced. Now let us go to B and give him the house. Come on, take your keys, take this document, the house is yours. That time can B say a no if he doesn't want the house? He can say a no. Why? Because the contract, it is not in the knowledge of, because it did not come into knowledge of A. That is the reason he's going and telling. For him, it is complete. He will have to give yes or no. But still, he did not know whether he said yes or no. Did not. So he went to him and said that, anyways, you wanted the house. No, come on, take this. I did not receive your letter. I know that you wanted the house. Come on, take. Can B say a no to it? Yes. He can say a no. Why he can say a no? Why? Because the contract did not come into existence for B. It only came into existence for A. Now say B still, it did not reach A. Now A is thinking that 11th happened, 12th happened, 15th happened, still I did not get the anything. Still I will sell it to some other person. Can he do that? No, he will have to sell it to B only. B can anytime come and say, I want the house, give me the house. But here anytime obviously means what time? Reasonable time. After obviously 5 years he waited. After 5 years he's coming and telling, come on, that time before 5 years you had to give me the house, give me the house. Obviously he would have sold the house 1 or 2 months or 6 months. He would have sold the house to some other person. Yes or no? That is not reasonable time. Reasonable time depends on facts and circumstances of the case. See, this is the reason act is given, law is given. Law is given. But still you have so many court cases. Why? Because still law is not very accurate or proper on some points. Say reasonable time also. They are saying facts and circumstances of the case. Now what parties will dispute? For me it is 3 months. For him he'll say it is 4 months. There'll be fight, there'll be conflict, then they'll go to court of law. Law is not saying anything. Law is saying that facts and circumstances of the case. So parties will get into dispute. Now facts and circumstances of the case will be decided by whom? Court of law. That will be final in that case. Clear? Yes or no with this? Understood? So these things can happen. Though this is awkward situation, but very much valid. Now say, another situation if I, let us read from here. Yes. Yeah, 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 yeah. I can go, 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 go fast. Anyone else? You also? Fine? Everyone is fine? Okay. Now, where the proposal is accepted by letter sent by post, communication of acceptance will be complete as against the proposer when letter of acceptance is posted. Yes or no? Posted means put in the course of transmission. As against the acceptor when it reaches the proposer, when it comes to knowledge of proposer. Did this everyone understood? Okay. Two ways, two we have to see in this. One for proposer, one time for acceptor. Time for proposer is when it is put in the course of transmission, and time for acceptor is when it comes to knowledge of proposer. Okay. The proposer becomes bound by the contract the moment the acceptor posted the letter of acceptance. Immediately the contract comes into existence for proposer. But it is necessary. It is necessary that letter is correctly addressed, adequately stamped and duly posted. From your point of sight, whatever you're posting, you should be doing it correctly. The mistake has happened from third party's side, not from your side, not from any of the parties' side. If it happens from any of the parties, you can anytime cancel the contract saying that the party you are at fault, I'm going to cancel the contract. But here, say if both the parties are doing everything correctly, third party did some mistake because of which the communication has not reached properly, then the law will apply here. Okay. In such an event, loss of letter in transit, wrong delivery, non-delivery will not affect the validity of contract for whom? Obviously for the proposer. For him, there is validity of contract has come into existence, it is very much valid. The acceptor will be bound by his acceptance only when the letter of acceptance has reached the proposer. That is which date in our example? 10th of July. If there is no delivery of letter, acceptance could be treated to be complete only from the point of view of proposer, but not from the point of view of acceptor. So, not from the point of view of acceptor. When acceptance is made of, okay, till now, whatever we have discussed till now, you have understood now? This is what till here we have discussed. Clear? Yes or no? So, these things can happen. Generally, don't you think it can happen? There's so many letters, it comes to some other address, there's wrong delivery, there's no delivery, something happens. Rarely it happens, but it can happen. If it happens, what is the case? For proposer, contract came into existence. For acceptor, contract did not come into existence. Okay, so proposer you have to do, and acceptor your wish. Do or don't do. Contract did not come into existence. You want to do, you want to buy, well and good buy. You don't want to buy, say a no and don't buy. That person will sell to some other person. Can proposer now force? You have sent, because of postal authorities it got lost, you said a yes, now you will have to purchase my house. No, contract did not come into existence for that person. You cannot force that person. But can that person force the offerer, the proposer? Yes. Why? Because for the proposer contract came into existence. Clear with this? Yes or no, everybody? Now, when the acceptance is made of instantaneous communication like telex, telephone, fax, email, contract, when it is considered to come into existence, contract, when the acceptance is received by the offerer. Here you change and write offerer. Obviously, acceptance when it is given by offeree, it should be received by the offerer. So please make a note, don't get confused. That should be offerer. Okay. So whenever it is received, done, finished, contract comes into existence for both the parties at the same time here. Instantaneous, only the confusion, only the change in the time, date, everything is only in case of postal communications. Otherwise, in rest of the cases, it is instantaneous, immediately. I will tell you, please purchase my horse. You say, yes, yes, I will purchase. Done. Contract came into existence. Clear with this? Yes or no? Okay. And the contract is made at the place where acceptance is received. Which case law did we see? Come on, tell me fast. Bhagwan Das versus, remember? What is the place where the contract came into existence? The place where acceptance is received. The same is the case for this also. Entros Limited versus Miles Far East Corporation. Okay, anyways, I'll tell you the case law, facts I'll tell you. Okay. So the contract is made at the place where acceptance is received. However, in case of call drops or disturbance in the line, the acceptance may not be valid, obviously. Say, for example, I'm calling and telling you I want to sell you my car, or I'll tell you I want to sell you my bike for 50,000 rupees. You're saying, okay, which bike? That blue color bike. Yes, yes. We have discussed the terms and conditions. Now you are about to say, yes, yes, I'll purchase. Before saying a yes, that the line goes dead. Okay. You are going on saying, yes, yes, I will purchase, I'm ready to purchase. But did your communication reach the other party? No. There is no response from the other party. So what law is saying that in case there is call drop or the line goes dead or something happens, there's disturbance, say there's some marriage going on and there's a lot of band noise where you cannot listen to the conversation clearly. So something happened where the communication of acceptance did not reach the offerer. Did contract come into existence now? No, it did not. And say in this case the acceptor is going on talking. Yes, yes, he is not aware that actually the communication is not received by the offerer. But here he should get a doubt that the offerer is not responding. He is not saying anything. Yes, yes, then I'll do this. There is no response. Then what he should do? What law is saying that when there is a doubt that the communication did not reach the other party, you should again make the communication. Again give a call, see the times, or you just confirm from him that did you receive the message, did you receive that I said a yes, either through call or through message. Something you should do where you should be confirmed that your message reached the other party. Okay, then only contract will come into existence, otherwise no. In what? In instantaneous communication also this can happen. Understood? Yes or no? Everybody, yes or no? So that is very important that the communication of acceptance and offer is received by the other party without any disturbance. Properly it is received by the other party. Then only the contract will come into existence. Otherwise the contract will not come into existence. Okay. Entros Limited versus Miles Far East Corporation. This is English case law. And after this case law only, your case law Bhagwan Das versus Girdhari Lal came into existence. Both gave the same decisions. Okay. See, this is Entros Limited and this is Miles. Okay. They entered into contract with each other. Entros was a person at London and Miles Far was a person at Holland. And they entered into contract for, say, copper cathode tubes, which is used for some chemical experiments or something. Okay, for those tubes they entered into contract with each other. I will supply, and he said, okay, I will take the supply for my experiment. So that was the contract between both the parties. Now what happened? This Entros Limited did not supply the tubes. Did not supply the tubes. Contract was properly entered. He gave the offer and this offer was accepted. Now, when the offer is accepted, what happened? Contract came into existence by for the parties. Once the contract comes into existence, compulsorily E will have to supply and M will have to pay the price. Yes or no? Now here E is saying that I will not supply. I am not going to supply. Now, do you think M can go to court of law? Yes, he can go to court of law and file a case. Now, the dispute was not regarding this. The dispute was main regarding which court of law they should go and file the complaint. He said, I will go to this court. He said, no, no, I will go to London court. And the other one said, I will go to Holland court. That was the dispute between both the parties. Okay. In this case, offer was made where? Offer was made by Entros in London, but it was received by Miles. Okay, offer was received here. Acceptance was made in Holland. Acceptance was made in Holland. Made where? But made by Holland to London. So where it is received? Where it is received? London. So place where acceptance is received, that is the place of contract. So here place of contract was decided as London. Therefore the jurisdiction court of London was having the capacity to entertain the suit, to take the suit. Got this point clear? So here place where acceptance is received. Always place where acceptance is received is always considered to be the place of contract. And wherever is the place of contract, in that jurisdiction you can file the case. The suit. Suit is nothing but the case. SUIT is suit. Suit is nothing but the case. Clear with this? That was the case law. It was only for deciding the place of the contract, as we have already discussed in Bhagwan Das versus Girdhari. But this was the first case law, and based on this decision, only the decision was given in Bhagwan Das versus Girdhari Lal. But it was in English case law. That is the reason again Indian courts, what they did, they again accepted the case. But generally, what happens once the decision is given in any case law, they will not accept. They'll just say that already it is decided, you see that case law, and the decision will be final. Whatever is the decision, that will be final on you also. But here again they gave the decision. Only because there was a difference. The Indian case wanted to give one more judgment, but it was the same judgment. Clear with this? Okay. Okay. Now did you clearly understood everybody? Communication of offer, communication of accept. Now, when it is instantaneous, then when communication is generally considered to be complete, when it is it comes to the knowledge of other party. That is only final. Communication of offer when it is complete, when it comes to the knowledge of offeree. Communication of acceptance when it is complete, when it comes to the knowledge of offerer. That is only final. When it is exchanged, when the other party comes to the knowledge of that offer and acceptance, then finished contract comes into existence when instantaneous. Only difference is when the communication is through. When it is through post, what happens? When the communication is complete, for offerer it is complete. When it is coming to the knowledge of offeree, that is same in instantaneous and postal also, but only the difference is where communication of acceptance. In instantaneous, tell me, when will the communication of acceptance will be complete? When it comes to the knowledge of offerer. That is for instantaneous. Postal, for proposer, when it is complete, out in the course of transmission by offeree to offerer. Okay. And when it is as against the acceptor, when it is complete, when it comes to the knowledge of offerer, then only what is complete? Communication of acceptance. Clear? Lot of confusion still, right? You have to go on reading this. There will be lot of confusion. Anyways, while winding up the class, again I'll ask you questions. Okay, again I'll ask you so that it comes to tomorrow also. Again 2-3 days we'll do this so that it comes to your mind properly. Okay, see, you will understand. Generally understanding is there, but you'll just get confused. Okay, offeree, offerer. Okay, as against the offerer, as against the offeree, there will be just a confusion. Understanding will be there. Okay, don't worry, we'll thoroughly learn that also. Don't worry at all. After 2-3 days also you tell me, ma'am, we are not clear, then again 1 week again we'll read that, starting 15 minutes. So don't worry, if you don't understand anything, we will make sure that you understand it properly. You have confidence on that. We will make sure about it. So you don't have to worry. Now why? Because why I'm telling you why? Because as per your understanding, you will get scared. Okay, I did not understand what will happen. Their students will get scared. So that is the reason I'm telling you now only. This is very normal. This topic is such that you will get confused. It is very much normal. So don't worry. We will thoroughly read it. Every day we'll practice and read it. Okay. Okay. Now next, communication of special conditions. This special conditions is nothing but it is not talking about specifically offer, it is not talking about specifically acceptance. It is talking about some special conditions with it which is attached with offer. Which is attached with offer. Okay. Say for example, if you go to some shop to buy some clothes. You're going to a shop and you're buying some clothes. When you buy some clothes, they'll give you bill. Won't they give you bill? And in at the back side or below the bill, you'll have terms and conditions. We are not going to guarantee the color. We are not going to no return. All these terms and conditions will be there. So, do you think generally everybody who's purchasing goods from the cloth, they will sit and read all the terms and conditions? You read or you don't read? Sometimes some people do that, sometimes some people ignore also. They don't read any terms and conditions. But here what law is saying that special terms and conditions are generally communicated tacitly. Are communicated tacitly. I told you before also what is this word tacit means? Silent. Silently, there is no communication. Silently, without any communication, there are actually communicated. There is no communication, but when they are giving you that bill, is it not communicated? Law is telling that it is communicated. And did you accept the bill? Yes, yes, okay, bill, okay, okay, this much money, I'll pay you this much money, I'm keeping the bill in my bag or pocket or somewhere else. Are you not accepting? When you're accepting that bill, it means you're accepting those terms and conditions also. You read it, you don't read it, that is your problem, you accept. Now you went, you wore that, you were very happy, wow, nice dress, nice shirt, and you gave it for wash. After wash, the color went off. Can you go to now? You're going to again to the shopkeeper. See, you sold me this shirt where the color is not proper, the quality is not proper. Take back the shirt. Now, what will they do? See, terms and conditions. No guarantee for color. No exchange. Keep that shirt with yourself. Oh, I did not read this. That is your problem. You did not read that. That is going to be your problem. When you accepted the bill, that means you accepted the terms and conditions also. For this point clear everybody? Yes or no? So that is what is given here. Communication of terms and conditions. Communication of terms and conditions is done tacitly. Acceptance is also done tacitly. Okay. Communication is done tacitly. Acceptance of the terms and the condition is also done generally tacitly. So what happens, say somewhere, sometimes you are on railways or some bus stand. So there what happens, there'll be a board will that the passengers should be responsible for their own luggage. The authorities are not responsible. You did not happen to read that nicely. You're taking the bag, going, enjoying. Okay, I'm going for the vacation. In your mind, that is only there. You did not happen to read any notices also. So now your luggage got missed. Now you're going to the authority. My luggage is missed at your railway area or at your bus stand. Now you have to go and find. Then what will that person do? Come, come, come. I'll take you to some place. Come, he'll go and he'll take you to that notice board. We are not responsible for any passenger's belongings. The passenger will himself be responsible. So when you wanted to board a train or bus from that area, you took a ticket. That means you have accepted that notice board conditions also you are accepting. Understood? So these are known as what? Communication of special conditions, where it is done tacitly, silently. No express communication, and acceptance is also done silently. You don't know you are accepting, but actually you are accepting it. Clear with this? Understood this point, everybody? Yes or no? Okay. This is what is regarding communication of special condition. Let us now read this from the material. Okay. Special conditions are conveyed tacitly. Acceptance also happens tacitly only without even realizing it. Sometimes you read it, sometimes you don't read it. Then also you are accepting it. That is what law is saying. Okay. That is the reason you have to be careful. Whenever you do something, do it carefully. Okay. Say for examples are given. When a passenger undertakes travel, conditions of travel are printed at the back of the ticket, which are sometimes brought to the notice of passengers, sometimes not. See, sometimes they'll say, see at the back of the ticket. Okay, it will be written also. Sometimes it may not be written also. If the ticket is given to you, you have accepted the ticket, done. Whatever is written on the ticket is accepted by you. Okay, it is the notice is given to you or the notice is not given to you. Sometimes those people may also tell you, please read all the terms and conditions, or they may not say. On the letter also, on the what you say, ticket also, it will be written, see at the back of the ticket for terms and conditions. Maybe you will see or you may not see. Okay, so it all depends on the passengers. In any event, the passenger is treated as having accepted these special conditions the moment he bought the clear. Yes or no? Sometimes these conditions are found to be displayed at the notice board of the airline's office, which passenger may not have cared to read. These conditions are considered to be communicated to and accepted by the passenger. Clear? Now the case law is Mukul Datta versus Indian Airlines. Mukul Datta versus Indian. In this case, what happened? There was a relative of Mukul who was traveling by uh, plane. Okay, he took the ticket of Indian Airlines. Now, what happened? He took the ticket and he boarded the plane. Plane got crashed, and the relative died in the accident. Now, Mukul Datta went to Indian Airlines saying that because of your negligence, that my relative died. Now you will have to pay me compensation. So there was his relative who was traveling. This relative died. Now, because of this, what did Mukul Datta say? For this, you have to give me compensation. Give me compensation. Now, those Indian Airlines showed Mukul Datta the ticket. At the back of the ticket, there were terms and conditions, and the second condition said the passengers are responsible for their own lives. The airport air authorities, the plane authorities are not responsible for any passenger's life. That is, see why? Because this happens not always because of the negligence. Natural calamities also happen. How can you make them responsible then? See, हाँ, बहुत बार होता है वैसा. आप कैसे responsible बना सकते हो उनको? बट हाँ, उनकी गलती है कुछ तो ऑब्वियसली गवर्नमेंट उनको ऑर्डर देती है आप देने के लिए. आप पर्सनली नहीं. जनरली सी व्हाट हैपेंस, negligence happens or the pilot was drunk, he did not drive. ये सब चीजें, many things happen. Okay, so in those authorities, inquiries are put, and in inquiries, if it is proved that negligence, see यहाँ पर हम लोग negligence नहीं देख रहे. There is no fault of the party. Contract came into existence without any fault of the party. Something happened. Okay, negligence अगर कोई पार्टी की है, then we'll see in your unit 5 breach of contract, remedies for breach of. कुछ गलत अगर आप करते हैं, आपको कंपल्सरी कॉम्पनसेट करना है अदर पार्टी को. यहाँ पर हम लोग जनरल केस देख रहे हैं. कॉन्ट्रैक्ट एंटर हुआ, बट बिकॉज टर्म्स एंड कंडीशंस थे, यू हैव टू फॉलो. नॉर्मली यू कैन नॉट से एनीथिंग, राइट? कुछ भी हो सकता ना. Anything can happen and the plane can crash. Yes or no? That is the reason. Say if that happens, so clearly all these things are actually mentioned. Why? Because for everything, how can they take the responsibility? You have to take your own responsibility. You want to travel, you should bear in your mind that anything can happen. Yes or no? Natural calamity can happen, and there can be something that can happen to your life also. So that is the reason they'll say that you will be responsible for your life. The authorities will not be responsible. And that was given as the second condition in terms and conditions. Therefore, the court also decided in the favor of Indian Airlines that they are not responsible to pay any compensation because there was terms and conditions, and when that person accepted the ticket, it is as if he has accepted all the terms and conditions. Passengers responsible for their life. Got this point clear, everybody? Yes or no? That was the case law all about. Hmm. Chalo, let us see the next point now. Where a launderer gives his customer a receipt, the receipt carries terms and conditions and are to be treated as duly communicated to the customer. Therein, a tacit acceptance of these conditions is implied by the customer's acceptance of the receipt. Though the customer did not say terms and conditions I accept. Did he say that? No. But what did he do? He accepted that receipt. You know, you go to dry cleaners, you go to those any launder person, then they'll give you receipt for whatever clothes, the bill, the receipt. There also there'll be terms and conditions for that. Okay, when you accept that bill, that receipt, it is as if you have accepted the terms and conditions also. Okay, so I'll tell you what it is. Lily White versus Manu Swami. Lily White versus Manu Swami. No, no. Lily White is the name of the dry cleaners. Lily White is का नाम. Lily White, the dry cleaners. Huh? Lily White versus Manu Swami. No confusion. Okay, sorry, no disturbance. Lily White. Now, Lily White are the dry cleaners, and Manu Swami, what did they do? They Here they are respondent and appellant actually. That is the reason. Actually, here case was filed by Manu Swami normally. Again, it was again filed by Lily Swami in higher court. Therefore, here Lily White is the appellant and Manu Swami is respondent. That is the reason it's coming. But actually, it is filed like this. See, Manu Swami, what did he do? He gave some clothes for dry cleaning. Sorry, not clothes. Sorry, he gave a sari. Sorry, he's not he's she. Manu Swami is a lady. Lady. Sari for dry cleaning. The sari was given for dry cleaning. It was very heavy sari. It was very costly. Okay, the sari was very costly. So what did she do? She gave the sari for dry cleaning to Lily White. Lily White accepted the sari. And now, after accepting the sari, what did Lily White do? Lily White gave a receipt to Manu Swami. The receipt had terms and conditions. And in these terms and conditions, one of the terms and condition was if something happens to the clothes, then they will pay only 15% of the market value of the clothes. What they'll do? They'll pay only 15% of the market value. Now, in this case, because of the negligence of Lily White, he happened to misplace the sari. There is no sari, only sari got lost now. In Under whose responsibility sari was given? Lily White's responsibility. It was his responsibility to properly, safely keep the sari in the safe custody. Is it not responsible of the dry cleaners to keep the clothes in safe custody? Yes or no? It is their responsibility. But here what happened? The sari got lost. Now Manuswami came. It was say very heavy, having some silver work, very heavy sari. Now, Manuswami came and told that you have to reimburse the entire value to me. But what did Lily White say? We will not do that. We will only pay how much? 50%. When you took the receipt, you accepted the receipt. What did you do? You accepted that term and condition. Yes or no? So you will have to accept it. You will have to take now only 15%. They went to court of law. Now you tell me in whose favor court have decided here? They have decided here, this is an exception. Why it is an exception? They have decided in whose favor? Manu Swami's favor, saying that you can place any terms and conditions, whatever terms and conditions you want, you can put, but those terms and conditions should be reasonable. Should be reasonable. It should not be something which is unreasonable. Now, seeing these conditions, don't you think there is some mischief in the mind of Lily White? What they can do? They can, yes, purposely they can sell the sari. Obviously, if they sell second-hand sari also, they can get at least 50% or 60% of the value. New sari, brand new sari, heavy sari. But how much they are paying? Only 15%. Rest of the value they can take for themselves. So here, the terms and conditions are such where there is some mischief seen. There is some wrong intention seen. something which is not reasonable, then it is considered to be cancelled. Law is not saying anything here. Did law say anything? What did law say? If you accept the receipt, it is accepted. It will happen in all cases. But in some few cases, only this will happen, and nothing is specified in the law. It is specified only in the case law. In all the cases, generally, do you think the court will give judgment in whose favor? Normally, they'll give in Lily White's favor only. But here, the judge was very intelligent judge who was having good knowledge. Therefore, he saw the case properly and he gave the decision. And this decision now became a law, saying that terms and conditions will be applicable to party only if they are reasonable. If there is some mischief seen or on a party's side, then you can cancel. You can say that those terms and conditions were not correct, were not accepted, therefore they are not valid. These cases we are telling. See what happens, same thing will be asked, same thing, same terms will be used, only names will be changed, price will be changed. Instead of Lily White, they'll say some other Today dry cleaners, or some other dry cleaners, they'll use some other names. And instead of Manu Swami, they'll say some Mr. Miss Asha, or some name they'll use, or Mr. also. Only what will happen, the names will be changed, and they'll say the same thing. That Mrs. Asha gave the sari for dry cleaning, and this dry cleaners, Today dry cleaners, or whatever it is, dry cleaners misplaced the sari. That person came for compensation to get the full value, but that person denied, saying that only 15%. Instead of 15%, they can say 10% also, 20% also. They can change the percentage also. Okay, but seeing the facts of the case, you should relate the facts of the case to the actual case law. Understood? You can say, as per the decision given in Lily White versus Manuswamy, you should write the decision that because the terms and conditions were not reasonable, therefore the court decided in the favor of Manuswamy, and the court decided to give 60% or 70, or the whole value also the court will decide. Whatever is the decision of the court will be final. Then Lily White will have to give that compensation. The same way you can apply. You can say that in the given case, therefore Mrs. Asha will have right to take the full compensation as the term of 15% was not reasonable. Likewise, you should correlate both the cases. Understood? In your own words. पूरा डिट्टो आपको नहीं लिखना है, in your own words लिखना है. जो केस लॉ है, whichever is the case law, that also you write in your own words. That is the answer, that is Lily White Manuswamy in your own words, as well as this also you can write in your own words. Anyways, the fact for this Today dry cleaners and Mrs. Asha will be given in the question itself. From question only you can write few points. For this point clear? Then therefore it is held that in this case Mrs. Asha will succeed the case as per the decision given in the case law. So that is the conclusion part. Only one line conclusion you have to give. The main answer will be first paragraph. That is your main answer. Second paragraph will be correlating the main answer and the question. That is your second paragraph. Third will be just the conclusion part, just one line part. That is how you have to answer. It can be case law also, it can be some section also. So you should write first paragraph will be always as per section 2, 3 of the Indian Contract Act. Say if the question is asked on communication of offer and acceptance, then as per section 4 of the Indian Contract Act, the communication of offer is complete. Entire thing you should write. When the communication of offer is complete, when it comes to knowledge, when in case of accepted, everything you should write. Then you should write, in the given case, the letter was posted on this date, therefore the communication is complete on as against A on this date, as against B on this date. First will be the main answer, second will be the relationship between question and answer. You should give the relationship just like that. Got this point clear? This is how you have to answer. Anyways, as you write the answers and questions, you will understand. That will be in your own words. See, these case laws will be half of the paper will be direct questions. Directly they'll ask you. Give the difference between void and voidable contracts. Give the differences. Or explain the essentials of a valid contract that you have to do. One will be the, what you say, those questions where statements are given. All illegal agreements are not void, but all all illegal All illegal are not void, but or void are not illegal. That whatever is the statement that will be given, explain. हाँ वो भी आता. ऐसे एक ऐसे क्वेश्चन कंपल्सरी यू विल गेट एक्सप्लेनेशन वाला एंड रेस्ट ऑल डायरेक्ट एंड फ्यू केस लॉज विल गेट. One difference compulsory. Any difference? Difference between offer, invitation to offer, or difference between agreement and contract that you get. Hmm? Entire paper will be like that. Law is like that only. In again sale of goods, partnership, again you will have differences questions also. You will have case laws also. You will have general questions also. You will have statements also. So any from anywhere it will be asked. You just make this point, keep this point in your mind that you have to be thorough with all the units, all the chapters thoroughly. Each and every point you need to understand properly. Everything you can write in your own words. Nicely you can write in your only definitions you cannot write. Rest everything can be in your own words. Side headings you mention for essential elements also. In the side heading part, in your own words you can write. Explain. Okay. Obviously. Obviously, the people are not what do you say 10th pass or 12th pass. They are chartered accountants who knows properly what it is. Okay. They'll get the key also, and you have to write it properly, everything. Okay. And they don't have so many papers that they don't have time to read each and every line. But if you mark important points, and side headings you write properly, then you will get marks. Without seeing each and every line, they'll give you marks. Like that it is. Okay, understood? Okay. So where were we? Okay, understood. Lily White versus Manu Swami. Yes. Now, understand this carefully. This also part. Raipur Transport Company versus Ghanshyam. So in this case, what happened? Raipur Transport Company versus Ghanshyam. Ghanshyam gave goods for transportation to Raipur Transport Company. He had some goods. Say he had some goods in Delhi. He wanted to transport it to Mumbai. So Ghanshyam, what did he do? He told Raipur Transport Company, you take. I'm just giving an example. Okay. Okay. It is something relation to obviously Raipur only. So Raipur Transport Company, you take the goods and transport it to that place, Mumbai. Okay. So in this case, what happened? Both the parties, he gave the offer, and this offer was accepted by this Raipur Transport Company. Offer and acceptance happened. So what came into existence? Contract came into existence. Now you tell me, whenever goods are transported, generally to take it properly to the other place, whose responsibility it is? Transport company's responsibility only it is. Yes or no? So everything was entered, contract was entered. Now, when the time came to take the goods, to load the goods, they loaded the goods. Now it was time to take the goods. Before that time, only what this Raipur company did, they circulated some circulars. Circulated some circulars. Circulars mentioning some terms and conditions. What were mentioned? Some terms and conditions were mentioned. Now you tell me these terms and conditions were communicated when? Very good. After the contract is entered. After the contract is entered. Whatever terms and conditions are entered, what you want to apply should always be mentioned before or at the time. That is very, very, very important. After contract is entered, now you say no, you have to do this only for me, you have to do that only. Do you think will it be valid? It will not be valid. So always terms and conditions should be mentioned before or at the time of entering into contract. Then only it is valid. After contract it is not considered to be valid. But this Raipur company, transport company, what did they do? They mentioned terms and conditions after. And one of the terms and conditions was that the transport company is not responsible for any loss of goods, the responsibility will be the owner's responsibility only. But because this was not discussed, when he submitted the circulars, after circulars also, the transportation was done. In the transportation, there was some loss of goods happened. What happened? Some, not always accident, same, some loss happened. Maybe accident, or because of the rain, something happened. Okay, the goods were lost. Whose goods were lost? Ghanshyam's goods were lost. Now Ghanshyam went to court of law to file a case, and the case was decided in whose favor? Ghanshyam's favor only, saying that any terms and conditions which are decided, which are communicated after the contract, is as if there are no terms and conditions only relating to contract. Therefore, they are not binding on any party. Binding means no party will have to satisfy those terms and conditions. They are not binding. For this point clear? Yes or no? So what happens? What law is saying, say when the contract was entered, that time only, if Raipur Transport Company gave a hint to Ghanshyam saying that we are accepting your goods, but we are just deciding on some terms and conditions. After some time, we are going to issue some terms and conditions that will be applicable to you. If that is also given, that will be valid. At least terms and conditions should be given, or notice of terms and conditions should be given at the time of contract. Nothing is given, then not valid. Clear with this, everybody? Yes or no? That is very important. Now you may get a doubt. He's saying at the time of contract, some terms of conditions we will issue. So is it not confusion in the minds of parties? But here, if there is confusion, the party will have to clarify. If there is any confusion, then Ghanshyam, can he say a no? He can say a no to it. Yes. But he is accepting that. He's saying that yes, yes, you give any terms and condition, I'm going to accept that. And finished. Contract came into existence. Was notice given for that terms and conditions? Yes. Either you specify or you give a notice that I will give you some terms and conditions. That you should do at least. Okay. Now let us read this. Understood, everybody, about this communication of terms and condition? Standard form of contract may be enforced on another who is subjectively unaware of the contents of the document. See, this is in continuation. There is no gap here. The provided the party is in continuation with the same line. Contents of, provided the party wanting to enforce the contract has given notice, which in circumstances of the case is sufficiently reasonable. Notice is such that he now understood that what is to be done, what was the offerer trying to do. He understood that. So it is reasonable. If you confuse that party, you're not telling anything properly, then it is not correct. Okay. So whatever notice you're giving, that notice should be also given clearly, properly, so that he can understand. But the acceptor will not incur any contractual obligation if documents so printed and delivered to him is in such state that does not give reasonable notice on its face that it contains certain terms and conditions. It is not reasonable. Giving the terms and conditions after entering into contract is not considered to be reasonable at all. At the time you give or before you give, very much reasonable, but afterwards you're giving, not reasonable, which is not considered to be enforced in the eyes of law will not enforce those terms and conditions, saying that it is not valid. Clear with this? Yes or no? Okay, this is nothing, this is very simple, we'll just complete this. Okay, communication of performance. Communication of performance, here what are they talking? Is communication of performance required? That means, can you directly without communication perform, or you have to first communicate and then perform? Generally, it all depends on the terms of your contract. If the offer is mentioning that if you want to accept, first give the acceptance, then perform the contract. Then you have to first give the acceptance or perform. Nothing is mentioned, then always communication of performance is not required. Just performing the act will imply as if you have accepted. For this point clear? Specifically mentioned to be communicated, communicate. If not mentioned, just perform. Okay. Now that performance will be how? The how will be that performance that is given in your Carlyle versus Carbolic. Was the what did the offer? What was the offer given by Carbolic Smoke Ball and Company? To inhale that smoke balls, okay, you will not get influenza. Follow the directions. Now, is there any requirement for the person who is going to inhale go and say I am going to inhale? Is there any requirement to communicate? No. Directly can they inhale? Yes. Was that valid for acceptance? That performance was considered to be valid acceptance. So this communication of acceptance is supported by this case law Carlyle versus Carbolic Smoke Ball and Company, where communication of acceptance was not required, just performing was enough acceptance. Just performing the act was enough acceptance. Okay, now let us see what are the important points that are coming from this case law. An offer to be capable of acceptance must contain a definite promise by the offerer. This OR is not separate, it is together. Offerer that he would be bound provided the terms specified by him are accepted. Carlyle versus Carbolic. In Carbolic Smoke Ball and Company, what is given here? Just you accept the terms, we will assume it as acceptance. You don't have to come and tell me same way. Just accept the terms, it will be as if you are accepting. An offer may be made. MAY. Okay, may be made either to a particular person or to public at large. Both are very much valid. You cannot say that it should be made to particular person only. Why? Because in Carlyle versus Carbolic Smoke Ball and Company, it was made to general public. Was that not very much valid? It was valid. If an offer is made in the form of promise in return of an act, the performance of that act, even without communication, should be treated as acceptance of the offer. No communication required. You only did what? Performed. Inhaled as per the directions. It is valid. Accepted. Clear? This is what is decided in this point. Clear with this, everybody? Yes or no? Okay. Now, fast you tell me. When is communication complete? Communication of offer complete. When is communication of offer complete? When the communication comes to the word reaches is not the right word. You should use what word? When it comes to the knowledge of offeree. When is communication of acceptance complete? When is communication of acceptance complete as against the offeree? When it comes to the knowledge of offerer. When is communication of acceptance complete as against offerer? When it is put in the course of transmission by offeree to offerer. Okay. Otherwise, in instantaneous communication, when is communication of offer complete? Come on. When it comes to knowledge of offeree, when is communication of acceptance complete? When it comes to knowledge of offerer. For instantaneous, this is the case. Only the difference is where? Difference is only in case of postal communication. Clear with this? Yes or no, everybody? Okay. So today, for this topic, we are going to stop. Okay.